ye, hear ye, hear ye. The Colorado Court of Appeals is now in session.
Good morning. Please be seated. Welcome to Division 2 of the Colorado Court of Appeals. We have two cases on our 9 o'clock docket today. We have People v. Steinfeld, and it looks like counsel are present and ready. And People v. Carbutt, counsel present ready for that? All right, we probably will not take a break between oral arguments, so you may come up as soon as this argument concludes. I think counsel are both experienced, but I assume you are familiar with our oral argument procedures. Any questions? All right. And I think you both also know, and for the spectators as well, can you please turn off any electronic devices as it does interfere with our recording equipment, even if it's silenced. That leads me to my next point. We are live streaming, and your oral arguments will eventually be on our video website. So if there's anything confidential or sensitive, please take care in oral argument to preserve the confidentiality. With that, I think we're ready for People v. Steinfeld.
May it please the court, my name is Meredith Osborne, attorney registration number 50469, and I represent Mr. Steinfeld. The sole issue in this case to be decided is whether Mr. Steinfeld was entitled to a provocation instruction. Under the Supreme Court case Castles v. People, Mr. Steinfeld was so entitled, and the trial court erred in his second trial in denying him that instruction. Heat of passion is a theory of defense that recognizes that sometimes the circumstances conspire to cause reasonable people to behave violently and passionately. As pertinent here under the second-degree assault statute, there are 4 criteria that need to be satisfied in order for the defendant to receive the instruction. First, the defendant needs to act in a heat of passion. Second, there needs to be a serious and highly provoking act by the victim. Third, the victim's provoking act needs to be sufficient to excite an irresistible passion in a reasonable person. And fourth, there must not be a sufficient length of time for the defendant to hear the voice of reason and humanity. A provocation instruction is warranted whenever a defendant shows some supporting evidence, regardless of how incredible, unreasonable, improbable, or slight it may be. And the evidence is viewed in a light most favorable to the defendant. In this case, all 4 factors were met. First, Mr. Steinfeld acted in a heat of passion. There was testimony that he feared for his life and he was upset. There was also testimony, and this is not referenced in the briefs, but that he blacked out in a whirlwind of emotions, and I'm happy to provide the court with the record cite for that as well, if needed.
Ms. Osborne, that was after he fled, though, isn't that correct? That wasn't prior to the lunge.
It's unclear what he's talking about when he says, in my understanding of the record, when he's talking about he blacked out, he says that he told the officer that he did black out, but that wasn't precisely the term that he would use. He was just so emotional in the heat of the moment. And he never clarifies, was this explicitly after or was it during the events in question? However, even if it was after the events in question, Castles makes clear that however slight or improbable the evidence must be, if the defendant can come forward with some kind of evidence, that's sufficient to warrant or satisfy at least that factor.
Well, Ms. Osborne, let me ask you, this case seems to fall a little bit between Castles and Spelfida. Are you aware of any provocation instructions where there hasn't been physical contact by the victim? So just a gesture or some action that the court instructed on heat of passion without actual physical contact?
There's no Colorado case that doesn't involve physical gestures by the victim. However, Millbrook, which is referenced in the opening brief, does talk about the words alone, and that was a series of escalating verbal interactions between the defendant and the victim, and eventually the victim did curse at the defendant and made a derogatory comment about his girlfriend, and the defendant reacted violently, and the defendant in that case was absolutely warranted, and this California Court of Appeals made clear that words alone, while not sufficient to warrant a self-defense instruction, are sufficient in certain provocation cases. And that's because the defendant may not have acted reasonably in using physical force, but did act in the heat of the moment, and so words can suffice for that.
Counsel, help me understand how, on the facts of this case, your argument would not result in a heat of passion instruction being appropriate in almost every single self-defense case simply because of the fear that generates the same act that grounds the self-defense.
Well, if I understand the court correctly, this is not a watershed case. This is a case that's almost identical to Castle's in the fact that there was physical and verbal gestures and actions by the victim.
Except there were significant differences in the level of vulnerability, the level of isolation, et cetera, in Castle's than there are here, correct?
Well, I wouldn't characterize Castle's in that way. I don't think that the Supreme Court hung its hat on just the clothes or lack thereof of the defendant in Castle's or the proximity to the victim and the lack of multiple escapes. In this case, there was evidence that the victim was significantly larger in size than Mr. Steinfeld, and the reign of terror was never going to end. And so I do think that this case is a principal example of the policy concerns at play in Castle's and other heat of passion cases.
What do we do with his own comments that he was not in a rage and that he had actually picked up the pipe to defend himself?
Well, to the extent that there's conflicting evidence, again, this goes to the jury. This isn't a case for this court to decide on the merits of the heat of passion. It's a case to decide on whether the jury gets to consider it under Castle's.
So what is there to support? I mean, obviously, he just needs to have some evidence. What is the evidence that this was heat of passion as opposed to self-defense?
Well, they're not necessarily at odds with one another. Many Colorado Supreme Court cases make clear that these defenses work together. One is a justification and one is a mitigation. And so the jury does not consider the mitigation unless it finds that there is guilt. So to the extent that there might be a conflict in his election at trial with self-defense, which is obviously a preferred defense, I don't think that that precludes whatsoever that he was entitled to provocation. Does that answer your question? Okay. Second, the victim's threats and lunge were highly provoking. The trial court said that this condition was not satisfied because words alone cannot warrant a provocation instruction, and also that the victim's statements could not be accumulated to suffice for this factor. However, the trial court did not consider the lunge whatsoever, and the fact that that alone could stand for the highly provoking act in this case. In addition, the victim's threats that today's the day, and there was some ambiguity in the record whether he also threatened later, when you come back out, you're going to get it. There's some conflicting testimony on that, but so there was more than one statement. And then immediately precipitating the lunge, the victim cursed at Mr. Steinfeld and then lunged at him. So Castle's does not parse out individual statements by the victim. It looks at it collectively. I think that it's somewhat misleading to say that this is an accumulation case like Sepulveda. It's not. This is a case that looks at the totality of what happened immediately precipitating the event versus a series of small slights months or weeks prior to the event in question that the defendant seeks to use as his evidence of provocation. It's highly distinguishable from those cases. Third, the victim's threats and lunge were sufficient to excite a irresistible passion in a reasonable person. Under the circumstances of this case, a reasonable person could find that, a reasonable juror, I should say, could find that it was entirely reasonable under the circumstances here for Mr. Steinfeld to behave as he did. And this factor is somewhat related, as the answer brief and opening brief recognize, bleeds into the second factor. And then finally, the interval here was not long enough for Mr. Steinfeld to hear the voice of reason and humanity. The evidence was that it was 30 seconds to a minute, and although the trial court tried to make this a legal ruling, there are cases directly on point that say even 15 minutes is not long enough, and to the extent there's any dispute, it goes to the jury. And the trial court actually got that right the first trial. This was the same judge, and he said at the instructions conference in the first trial that it's not about what we think, it's not about what counsel think, it's not about what I think. This interval of time goes to the jury. And to the extent there's a dispute, let them decide it. That's what the fact finder does. So for these reasons, Mr. Steinfeld was entitled to the provocation instruction, and he was certainly harmed by it. Sepulveda, although this is somewhat dicta, says that if the defendant is entitled to the instruction, he is clearly harmed by a denial of that entitlement. Castles also makes clear that this is harm under any standard of review or reversal, and in this particular case, Mr. Steinfeld was denied his constitutional right to present a defense. He was denied the prosecution's constitutional burden to disprove the provocation mitigator beyond a reasonable doubt, and there were significant differences in the penalties he faced by a denial of this instruction. So for these reasons, although the trial court properly recited the Castle standard, it incorrectly applied it to this case, and Mr. Steinfeld was entitled to the provocation instruction, and he respectfully requests that this court grant him a new trial in order to receive that instruction. And if the court has no further questions, I would like to reserve the remainder of my time for rebuttal.
Let me ask, you're saying you grant him a new trial, but this is a mitigation issue, is it not?
Correct.
So he's been convicted, and you would only get to mitigation if he's convicted. Why would we reverse?
Well, yeah, I understand the court's concern. In Castles, it's a new trial for provocation. That's the relief that he's entitled to. The evidence would certainly come back out yet again that Mr. Steinfeld was provoked, and the jury needs to hear that evidence. Perhaps that's something best left for remand, but it is pretty clear from Castles that the remedy is a new trial.
Thank you.
Thank you.
Thanks, Ms. Osborne. You'll have 4 minutes and 52 seconds.
Thank you.
May it please the court, I'm Christine Brady, registration number 24779, representing the people. The key to this case is the standard for giving the sentence mitigating defense, which is in the light most favorable to the defendant. There isn't any testimony or evidence that could be more favorable to the defendant than his own testimony, and in this case, the defendant did decide to testify in his own defense. So here, the defendant's testimony was, and this is in both of his trials, it was the same defense in the first trial as in the second trial, and there was an instruction given about this imminent threat of the victim making a threat and lunging at him. In both of those trials, he said he was defending himself. That was his testimony. And the very nature of thinking things through that I need to defend myself. It is true, and it wasn't disputed, that there were these threats over several months. He did testify that there was a threat that morning. He testified that after the verbal threat that morning, he went to his truck. He continued packing things up there. He went to his supervisor's office and told him what was going on, told him that there was this other witness, an objective witness, who was in the cargo bay, who saw and heard everything that was going on. He waited for his supervisor to go talk to that objective witness. Then he said he grabbed the pipe and followed his supervisor out to where the supervisor was going to talk to the victim and find out what was going on with the situation. So in all of these cases, and they say that it's very case-specific, I don't know if any case is really on point and can really give us a solution to this case, but whether it's, there are cases that say 1 minute is enough to reflect. Some cases say 1 minute is not. Some cases say 2 hours is enough to reflect. It's not the time increment. It's what happens in that time. We have to look at, did this particular defendant in this particular case reflect? And the very nature of...
Counsel, let me interrupt there. Doesn't that, as Ms. Osborne said, doesn't that put the issue of the merits before us? Isn't the question more, could a jury find on this evidence that there wasn't sufficient time to reflect?
No, I think that the trial court, as, trial court did in this case, can look at it and say, okay, I'm looking at what happened in this particular increment of time, and as a matter of law, he actually did reflect. I mean, this is a good case for that, is that his own testimony, he said, I was defending myself, and here's what I did. And he gave the jury his rendition of what happened. This isn't something that we're finding out from other witnesses that might be biased. This is a defendant saying, yeah, I was defending myself.
Are you not suggesting by that argument that the two are then inconsistent, fundamentally inconsistent? In other words, if you have enough time to contemplate the need for self-defense, you by definition cannot be acting in heat of passion. Is that the suggestion I'm hearing?
No. What I am trying to suggest is that it's not the increment of time. It's what this defendant is saying that he did in that amount of time. His defense did not change from the first trial to the second trial. It was the same instruction in both cases, where he said, I reacted to an imminent threat, which of course parallels the self-defense instruction. I don't know how you can, at the same time, on the one hand saying, I reacted to an imminent threat, I was afraid for my life, I was defending myself, and then say, as the other cases would have us believe, is that, oh, I lost it. I didn't know what I was doing. There was no thinking involved. There was definitely thinking involved.
So you're saying those are two, again, I'm hearing you say that those are inconsistent. You can't have both defenses. And Harris would seem to suggest otherwise, would it not?
I think based on the facts, and that all of the cases say this is very fact-specific, and based on the facts that we have in this case, you cannot, as a defendant, testify that I was thinking this through and I was defending myself when there's no other testimony that, well, when the time came, I just lost it, I didn't know what I was doing, and I just reacted. That's not what his testimony was.
So, Ms. Brady, hypothetically, under these facts, you're not arguing that a lunge itself could never entitle a defendant to heat of passion. It's just based on the testimony and what happened here and his state of mind as he conveyed it to the jury. That wasn't enough in this case. Is that where the people are?
I think that's correct, that wasn't enough in this case, although I would say, in general, I understand that he had been threatened for months. That was not contested. And this man was bigger than he was, and his testimony was that the man lunged at him. I think there's a difference, though, between a lunge is provoking. We can all agree on that. Someone is larger than you and they're lunging at you. That could be provoking. But we put the modifier on there, which is highly provoking. So we're distinguishing between something that could be provoking where you would want to defend yourself, and that's something that we can all understand. Highly provoking is the modifier that we put on there because this is something specific that we want to distinguish it from self-defense.
Ms. Brady, let me ask, is there evidence that that Roberson's actions at the time, at that moment, were provocative?
Well, again, we're looking at the defendant's testimony.
I'm just asking about the victim.
Okay.
Was the victim's conduct, can it fairly be said that it was provocative?
According to the defendant's testimony, Yes, he.
Okay.
Yes.
And that, thank you,
He
according to
was
his
provoked.
testimony.
He was provoked, right.
Yes.
And that was again, I understand that we're looking at in the light most favorable to
Mm-hmm.
the defendant. He was the only one that testified to that. No one else saw this lunge or heard the threat. But yes, according to his testimony, that was what provoked him.
And all that needs to be is that there is some evidence, if believed by a reasonable juror, would satisfy one element, one aspect of the defense.
Well, I don't think we want to say that we submit it to the jury every time there's some kind of provoking act, because any kind of provoking act can provoke someone to defend themselves.
Well, I understand, but but we have to look at what's necessary to have some evidence. And my notion here right now is if the jury believed what he said, then there is some evidence that the victim acted in a provoking way. And so then my next question then is, are we looking at, again, at the quality of what the victim is alleged to have done? Would that be sufficient to raise in a reasonable person a heat of passion, unrefutable reaction? Is this still not talking about this defendant? Am I correct about that? That all we have to do is, that one aspect of what we have to do is to say, is there some evidence of a provocation, and was that provocation of this nature?
The trial court is a gatekeeper to decide if this type of action would cross the line to the point where a reasonable jury could find that this was a highly provoking act. And in this case, the trial court looked at it, having heard the evidence from the first trial, where, and again, yeah, it was the same judge, where the judge decided to give the instruction, and then having heard the testimony, which was basically the same defendant's testimony in the second trial, as the gatekeeping function decided no. And I mean, I think that if we're going to say that any provoking act is something that needs to be submitted to the jury, then what we're saying is anytime there's a self-defense instruction, that we also have to give the sentence mitigator. And I don't think that's what the law says.
All right, so, and I don't disagree with that, but my concern here is that there is some evidence of provocative conduct, and there's a question of whether a juror could infer from that this was so provocative that somebody could really blow their top and react. And so then the question becomes, that period of time that you're talking about where he did other things, does that close the door for him that he was thoughtful before, but now something else happens and he can no longer have a heat of passion because in a minute before he was thoughtful, so he must necessarily have been thoughtful now?
Well, in the abstract, Your Honor, I would agree with you that it doesn't close the door. And it would just be the facts of this case and the trial court's recognition that in
Thank
this
you.
case, he thought about it. And then just one final point, I believe. There was a question about the remedy in this case. If you decide that that the defendant's argument has merit, that we don't need to reverse and remand for a new trial. It would be the prosecutor's option to just enter the F6, with the sentence mitigator to enter a conviction for the F6.
I'm sorry, Ms. Reyes, so that would look like it goes back and then the prosecuting attorney makes a decision and informs the trial court?
That's correct.
And has that been, can you cite us to any authority where that's been done?
Actually, I cannot.
Okay.
But not in these particular circumstances, but there has been circumstances where there's been evidence, for instance, of a lesser included offense, and it was the prosecutor's option to just enter for the lesser included offense.
So the prosecutor would have the option under your scenario of choosing the lesser offense or a retrial on the original charge?
That's correct,
Or
Your
on
Honor.
the, and this, yeah, okay, thanks.
Thank you.
Thank you, Ms. Friday.
Just a few final points on some of the topics that came up. In Castles, the defendant testified that he had retrieved his gun to scare the victim, and that there was some evidence that he intentionally and consciously thought about his conduct in that case as well. And the court did not parse that out and find that to be prohibiting the provocation instruction in that case. Furthermore, in Castles, the remedy was a new trial. The jury had rejected self-defense in that case, and the court did not distinguish that and ask for a remand for entry on the 6th, or I'm sorry, in that case, whatever the lesser felony was. Furthermore, Castles said that heat of passion is consistent with self-defense. And finally, in this case, although Mr. Steinfeld's testimony served as the basis for a lot of the evidence warranting provocation here, there was corroborative evidence from other witnesses about the lunge and the statements that were made by the victim, so it's not just his self-serving testimony. And to the extent that that was a concern in Castles, the Supreme Court didn't say so. So I don't think that that matters. It's however improbable and however slight, that is the evidence that allows the fact finder to make this determination, not the court. And I think to the extent that this court has gotten into the weeds about what the evidence showed, what the evidence didn't show, is it highly provoking or is it just provoking? I think that that actually reveals that this was a question for the jury, and the trial court, again, thought so too at the first trial. So
let me clarify on that one. Are you suggesting that because the standard is that if there is sufficient evidence to submit a self-defense or mitigating factor, the sufficiency of the evidence to submit it is so low that any hint of any aspect of provocation, even if that provocation could never, no reasonable jury could say that's highly and seriously provoking, that they still need to get that instruction? In other words, doesn't the trial court, as gatekeeper, have to make some determination as to whether this provocation is sufficient to get to the jury?
yes, of course. The trial court needs to say, as a matter of law, no reasonable juror could ever find this. That is what Castle says. That is what Sepulveda says. That's what other cases say as well. And to the extent that there's a dispute about the evidence, it needs to go to the fact finder. That's what the jury trial is for. And here, the court did say, yes, at the first trial. I actually am very persuaded by Justice Coates' dissent in Castles, where he says, words communicating information alone can warrant this instruction. The court found that very persuasive. Here, we don't even just have words. We have the lunge, which the trial court elected not to consider in the second trial. So again, I do think that there is a gatekeeping function, but the burden to get the instruction is far lower than what the jury would actually have to find. And the question before this court is whether the jury was allowed to consider the mitigator at all. And I think that the jury absolutely was, and Mr. Steinfeld was entitled to the instruction. So for that reason, he respectfully requests a remand for a new trial from this court.
And on the issue of the remand, I understand that Castle's reversed and sent back for a new trial, although there's no indication that the alternative remand was suggested in that case, correct?
Correct. I'm not sure entirely from the case law whether this court has the authority to enter the provocation verdict for the jury. The jury gets to consider this, and I think the new trial is necessary based on the evidence that needs to come out, and the jury needs to weigh and consider this again.
But do you acknowledge that there are cases where, at least in the context of lesser includeds, for example, if there was an instructional error on a first-degree murder, that the intoxication defense was improperly instructed? There are cases where it was sent back with a remand instruction that said the prosecution can either elect to accept second-degree murder conviction or retry, and that would be up to the DA. Do you acknowledge that those cases exist, at least in the context of lesser included offenses?
I'm willing to acknowledge they exist. I'm not willing to
Is there a
acknowledge.
reason to treat a lesser included offense differently than a mitigating factor in that context?
I'm not sure, to be honest. I'm not sure if there would be a reason to treat it differently. What I can say is that Castles did not make any analysis, give any guidance to this court about what the proper remedy would be, other than to say if the jury has denied it, the remedy is a new trial. So I'm sorry that I can't give the court any further information about the lesser included cases.
Thank you.
And I see I'm
Thank
out of
you.
time. Thank you very much.
Thank you, Ms. Osborne and Ms. Brady, for your helpful arguments today. People versus Steinfeld is submitted, and an opinion will issue in due course. And as you depart, counsel from People versus Carbutt, please come forward. And I believe you heard all of our instructions earlier. Does council have any questions on our procedures? All right, then you may proceed when you're ready.
May it please the court, my name is Joe St. Veltri. I and Kelly Cherry represent the defendant appellant in this case, as we did during the trial proceedings. At the outset, I would like to suggest to this court that the case before it involves a sex-related offense, and that in and of itself engenders certain complications for this court as a reviewing court, as it did for the trial court. It is our proposal that the Rule 11 proceeding before the trial court, which resulted in the defendant tendering a plea of guilty to a Class 4 felony, were generally incoherent. The plea he entered and was ultimately accepted by the court and sentenced on resulted in him, in the first instance, receiving a sentence of 15 to life. That sentence was clearly, conspicuously, and unmistakably illegal, a fact which was unnoticed by anyone at the time of his sentencing. On the motion of the defendant post-conviction, the trial court amended the 15 years to 12 years. The principal argument that the defendant appellant makes is that the Rule 11 proceeding, as I have described it, was incoherent. And by that, I mean that in reviewing it, there are several glaring and, in our view, alarming omissions that were made by the trial court. At the outset, the plea paperwork was not complete. This was not made known until post-conviction motions had been filed. At the time the defendant tendered his plea of guilty, the plea paperwork did not contain a specific section which describes the punishment for sex offenders, that is to say, people who are pleading guilty to a sex-related offense. The trial court, in my view, in a somewhat cavalier later ruling contended that the colloquy between he and the defendant cured that problem, notwithstanding that at the time the plea of guilty was entered, no one, not the defense attorney, not the prosecutor, nor the judge, ever noted that that part of the plea paperwork was missing. We
Well, Mr.
submit.
Sanvetri, excuse me,
Yes.
would you agree, though, that a colloquy can later clarify what could be a ambiguous plea paperwork? I mean, that does happen, and you agree generally that that's appropriate?
Yes,
Okay. You just don't think it happened here?
yes. I am maintaining that it did not happen here, and I perhaps can elaborate on that at this juncture by imparting to the court that the plea paperwork is contradictory and incomplete and does not provide a cogent explanation to any defendant of the penalties that are possible upon the entry of his plea of guilty. In conjunction with that, the trial court, in what I would describe as a failed attempt to cure the defects and the deficiencies in the plea paperwork, conducted an rather extensive colloquy with the defendant. We note that the defendant's answers to the judge's various inquiries were both abbreviated and very limited in number. The court repeatedly used the word could in conjunction with the maximum penalty which the court was required to impose.
Let me ask you a question on that. When you read the comments in context, the court says the nature of this case, this charge would require an indeterminate sentence. So it would be for the rest of your life. It could be prison, it could be probation. Where in that context could it be anything other than to life?
The court identifies one of the colloquies, I believe, that occurred. I believe after that colloquy, there is two other colloquies during which the trial court uses the phrase, I could, if I were to impose a sentence, I could impose a sentence which would be indeterminate. The court.
So, if I may, the court has said to Mr. Carbutt, this requires a life sentence. It could be either probation or prison. Later, he says something that your assertion was something different than that. If there is confusion, is it not Mr. Carbutt's obligation under the De Guglielmo case to speak up and say, I'm sorry, I'm confused?
There is that obligation, and Carbutt did not avail himself of that opportunity, and we concede that. However, overlaying that consideration that he, Carbutt, on his own behalf, had the duty to seek clarification, we maintain that the interfacing of these several different phrases and formulas that the court used would have deterred him from asking that question. And by that, I mean that the sentence that was actually imposed is currently 12 years to life. There is, under the sex offenders statute, the requirement that the sentence be indeterminate to life. The antonym of indeterminate is determinate, and it is in fact the the statute itself requires natural life. The court never, according to my recollection of all of the colloquies, told the defendant that if I sentence you to the Department of Corrections, I will sentence you on the, quote, bottom, to use the vernacular, to a term between 2 and 6 years, and as a maximum sentence, I will sentence you to life, which will require you to serve a life sentence in the Department of Corrections. So I agree with the court that in a typical case where there is not the complications that are inherent in a sex-related sentencing, the defendant has that duty. I submit in this case that he was deterred from making that inquiry of the court simply because of the nature of the proceedings and because it was so complicated, and moreover, that the complications were compounded by the fact that his attorney himself and the district attorney were unaware of the nature of the crime, which is reflected in the record at the beginning of the case, and that the paperwork itself is contradictory, and that the court on 2 occasions had to correct the statements or at least the positions that were announced by both the district attorney and by the defendant's own counsel.
The requirement that a defendant speak up seems to me to be rooted in the understanding that the inquiry is, by the trial court, is supposed to be, I need to make sure this person understands what he's doing. And if he looks to me like he understands what he's doing, and when I ask him if he understands what he's doing, he says yes, I, as a trial judge, can't say anything other than, I guess he knows what he's doing. I'm eyes on, I'm seeing him interact with me, I'm hearing his answers. Is the trial court not in a far better position than we are to say whether on this record he understood, Mr. Carbutt understood what he was doing? In other words, shouldn't this be treated like a finding of fact? It is a finding that it's knowingly and voluntarily entered into, correct?
I think it should be treated as a deficient Rule 11 advisement, which has constitutional underpinnings and therefore should be reviewed by this court de novo. And I think the court, in answer to the court's last question, in a case involving a life sentence, one would expect, notwithstanding the court has eyes on and is in the position of questioning the defendant, would have done a more complete inquiry of the defendant, such as telling him that it is mandatory. I have no discretion. I am required, if I sentence you to the Department of Corrections, in this case, to sentence you to life. No such colloquy or exchange occurred between the court and the defendant in that regard. There was a brief, fleeting, I would characterize it as, comment where the court said, "Are you understanding this?" And the defendant, in an abbreviated answer, said yes. I would submit to the court that that is not adequate in a case involving a mandatory, non-discretionary life sentence if the defendant is sentenced to the Department of Corrections. And I would also suggest that in these cases, and I don't mean to single out and create a new category of cases that require new applications of principles of law, but it would seem to me that this case, which does involve a mandatory life sentence, there should be a greater degree of concern that the defendant is fully aware of the possible maximum penalty, which did not occur in this case. May I reserve the remainder of my time unless the court has, any of the judges have an immediate question?
You may, and you have 2 minutes and 30 seconds.
Thank you.
Good morning, Your Honors. May it please the court. My name is Brian Lanny. My registration number is 47486, and I represent the people. I agree with defense counsel that the plea paperwork here did not provide information regarding an indeterminate sentence. But the standard, the inquiry at this point is whether there was sufficient information presented to the defendant so as to put him on notice of the matter in question. And the matter in question here being that whatever sentence the court imposed, it was going to be an indeterminate sentence. And the answer is yes, that was conveyed.
Mr. Lanny, let me interrupt you, I'm sorry. When the judge made this Rule 11 inquiry, was the judge aware of the deficiencies in the Rule 11 paperwork?
I think the answer is yes. I agree that the court didn't expressly say there are things missing from this paperwork, but what did happen was that when the parties came into court, the first thing that happened was the court said, listen, I've looked this over and this is not a crime of violence and this is not an extraordinary risk crime. And that was the first exchange that happened right off the bat, and there was an exchange to the effect of, well, that's good. I had advised my client as to the extraordinary risk maximum, so that's coming down. And at that point, the court says, yes, but, and this is what I think it implies that it was recognizing the deficiency in the paperwork. The court says, but ultimately, this defendant is now subjected to indeterminate sentencing. And that kind of leads me into my next point here, which is that the context matters of these statements, and particularly the order that they were made in, because after saying that, ultimately, we're talking about indeterminate sentencing here. The very first thing the court says is that this is a sex offense you're pleading guilty to. This court is required to impose an indeterminate sentence. And that's not an ambiguous statement, and it's not an equivocal statement. And what follows then is the statement that there was some discussion of here a minute ago, which is that it could be an indeterminate prison sentence, it could be an indeterminate probation sentence. And in that context, the use of the word could, what the court meant was it could be prison up to indeterminate, it could be probation. What it didn't mean in that context was it could be indeterminate prison, it could be indeterminate probation, it could be some other thing that I'm not mentioning. So I think the context shows that that wasn't an ambiguous statement, it wasn't an ambiguous use of the word could.
Let me ask you, never mind, go ahead.
Well, Mr. Lanny, I have a question then. So I think everyone agrees that the plea paperwork was confusing and incorrect. And we have signatures or initials by the defendant on the crime of violence saying, here's what the sentence is going to be. Court says that's wrong. We have the extraordinary risk circled and initialed. The court says that's wrong. How much is needed to clarify what is clearly bad plea 11 paperwork?
I think enough that satisfies the standard that's set forth in Benavidez, which is looking at the record as a whole, which means including the paperwork for what the paperwork does get correctly and for what it doesn't get correctly, and looking at the court's colloquy and how the two work together. And I think on this issue, the indeterminate issue, the paperwork didn't offer information about indeterminate sentencing. It had a chart about felony determinate sentencing, but again, the first thing that the court did in its colloquy was explain that's what happens when you plead to a normal felony. Those are the presumptive ranges for a determinate sentence. And it explained then that that's not what we're doing here. The court here is going to be required to impose an indeterminate sentence.
So would you concede that even the colloquy wasn't a model of clarity?
I think certainly the court could have gone into more detail and could have been more repetitive. But I don't think that this colloquy a defendant could have walked away from it believing that there was a determinate sentence on the table.
In the context of a colloquy curing incorrect statements in paperwork, is there some point at which a trial judge should say, okay, you got this wrong, you got this wrong, you got this wrong, I'm putting the brakes on everything, let's redo the paperwork correctly, let's make sure this is solid? Is there some point where the trial judge has that obligation to actually stop and restart the process?
I think that point does exist
And
in
is
the
this
universe
case,
of possibilities.
obviously your position is this case isn't there, but is it close to that line?
This case isn't there, is my position, and I don't think it's close to that line. For more than one reason, one being that I think the colloquy itself was clear when it's read from beginning to end in context, but I also think that approaching that line, a court would be, I don't know about obligated, but it would make sense to halt the proceedings and say, let's get this paperwork in order. If, for example, the defendant is not responding with, yes, I understand, yes, I understand, and he's instead responding with, I'm not sure that I understand that, Your Honor. And I want to point out that the defendant's responses here weren't just like short and perfunctory in the sense that he wasn't listening. In fact, I think the record shows the opposite. At one point in the transcript, and this is after the court has said, the comment that I was referring to could be prison, could be probation indeterminate. And then the court says, if I placed you in the Department of Corrections, the court would be required to impose at least the minimum of the presumptive range all the way up to life. And then, I mean, this comment, which again is not ambiguous, what indeterminate sentence means is life in prison. And at that point, the court says, do you understand that? And the defendant says, understand. And the court says, that's very significant because, and he's cut off by the defendant. I mean, that's what the transcript shows, is a hyphen. And the defendant says, he's explained that to me, referring to counsel. So we know that this isn't the first time that the defendant's hearing about indeterminate sentencing.
Is that an accurate definition? An indeterminate sentence means life in prison?
I think it's an accurate statement in that any sentence that's indeterminate includes a term that could include the person's natural life, which is what the court meant when it was using the word could after this point in the transcript. So it is an accurate statement.
So indeterminate means life in prison. That's what you're saying?
It means that regardless of the floor, the minimum, the potential is there that the person will be spending life in
Well,
prison.
that's what you're saying, right? And so
Correct.
indeterminate means that the total length is not determined
Correct.
by the court.
Correct.
It does not mean life in prison.
Correct. It means
It's a practical effect. It is life in prison, perhaps.
yes, and I agree with that statement. Yes, I think
So,
that's
so when the court says by indeterminate means life in prison, that's not accurate, is it?
I think it's accurate in the context of what it's saying because it's just said that it's going to be required to impose the minimum, at least the minimum of the presumptive range up to life in prison.
So what happens, the notion is that a defendant has to say that he doesn't understand.
Mm-hmm.
What if the defendant misunderstands? So he's saying there, I understand, and he doesn't understand at all. It's not that he's confused. It is that, okay, I understand. An indeterminate sentence is that you have the ability or the power to put me in prison for life, but I don't think you're going to do that, so I'm okay.
I think that situation could happen. A defendant could misunderstand, in which case he's not in the realm of de Guglielmo, where, if he's sitting there confused is when he has a duty to speak up. But I don't think the court's comments here were misleading to create that impression. I think to the extent that a person is sitting there thinking, I can get a sentence here that's fixed, but that could be 2 years, fixed, determinate. That would be dispelled immediately when the court says, I'm required to impose an indeterminate sentence. What indeterminate sentence means is life in prison. At that point, I don't think a person could be sitting there still misled about what they're facing. Confused maybe, in which case that person wouldn't cut off the court and say, you don't need to explain to me, you don't need to explain why that's very significant, which is what the court was about to say. He's explaining to me, I understand this.
Well, Ms. Shalini, I don't understand that. If the sex crime just came up at sentencing, since everyone apparently missed it, how could counsel have explained indeterminate to him?
Well, I
It
think that
seems
this shows that this wasn't the first time it was explained to him. And actually, there was a post-conviction evidentiary hearing in this case in the record. And while it wasn't particularly probative as to this issue because it was limited in scope to an issue of ineffective assistance of counsel, which is not raised on appeal, there were questions there put to defense counsel about whether he talked to the defendant about sex offenses and the attendant sentencing. And he said that he did talk to him about that. This occurred on March 1st of 2017. I think it's a supplemental transcript on page 10 of it. And the question was put to him if he had advised him about indeterminate sentencing, and his answer was absolutely. He knew he was facing the possibility of 6 years to life. So it doesn't tell us everything, but it shows us that this wasn't the first time that the defendant had ever heard about indeterminate sentencing. And that's consistent with the Providency hearing transcript itself, is my position, my reading of it.
So I have another question. We have the indeterminate issue, but then we have the bad plea work, and then we have the colloquy that doesn't ever really clarify the minimum sentence. I mean, there is some confusion about that as well, and we certainly don't have the defendant ever saying, I understand the minimum.
Right.
What do we do with that?
And that was the second issue. I guess I split those out to two issues. And with respect to that issue, I think the plea paperwork did have correct, useful information here. And by that, I mean that it did accurately convey the presumptive range for a Class 4 felony, which was 2 to 6 years. And it did accurately convey that upper end of that range would increase to 12 years in the presence of extraordinary aggravating circumstances. And it did convey in a paragraph initialed by the defendant, where paragraphs surrounding it were not initialed, where he wrote NA, that extraordinary aggravating circumstances existed here that would justify a sentence in the aggravated range, and that he agreed to such a sentence. So I think to that degree, the plea paperwork here did provide some of the requisite information.
So although the trial court didn't inform him, he was supposed to go back and look at the plea work, which we've agreed several portions of it were incorrect or ambiguous, and they misstated pages of the charts, and he was supposed to discern that from the paperwork.
The trial court only informed him about this detail to the extent that at the outset of the Providency hearing, it said, the normal range for a Class 4 felony is 2 to 6. If I find aggravating circumstances, that goes up to 12. And then it launched into, but this is not you're pleading to a sex offense, so it's going to be an indeterminate sentence based on those ranges. And I agree that thereafter, the court did not mention the 12-year increased range. It did emphasize several times the 2 to 6 year presumptive range, and it called it the presumptive range. So I don't think the court said anything that would have foreclosed in someone's mind the sentence beginning in the aggravated range. And I think, for what it's worth, the record of the sentencing hearing shows that the defendant did understand that he was facing a sentence that could begin an indeterminate sentence with a minimum higher than 6 years, because the prosecutor got up and argued for a 10 to life sentence, a 10-year to life sentence. And then defense counsel got up, and whether defense counsel was confused or not, defense counsel didn't say that's in the aggravated range. That wasn't within the scope of this agreement. That wasn't what I advised my client. The defense counsel argued that wouldn't serve society. We think probation is better. And then the defendant got up himself, and he said he could think of nothing that he could say to add to what has already been said. And he awaits the court's judgment. And I think that, for what it's worth, that shows that he wasn't sitting there when he heard 10 to life thinking that's not something that's supposed to happen here. So I think that the sentencing hearing lends some support to my argument that the plea, with respect to the minimum, the plea paperwork and the colloquy provided sufficient information to put this defendant on notice of what he faced.
So are you saying that the plea paperwork and the colloquy provided sufficient information, or are you saying it appears, based on the defendant's comment after the sentencing argument, that he understood?
I'm saying that, I'm saying both. I'm saying that the paperwork and the colloquy together, looking just at those together, provided sufficient information. And recognizing that it's an objective standard for what it's worth, I guess I'm qualifying it in that sense. We don't see a person that appears to have, be surprised that that the prosecution's asking for a sentence beyond that. I see my time is up. If the court doesn't have further questions, I rest on the arguments in my brief on the remaining issues. Thank you, Your Honors.
Thank you.
If I may contradict counsel for the people, the plea paperwork does not provide for a chart, does not provide a chart or any other indicator, any other indication that the sentence in this case could be more than 6 years based upon an aggravating circumstance found by the judge, which was a non-designated statutory aggravator. That does not appear in the paperwork. The paperwork mistakenly includes extraordinary risk crimes, of which this was not one, and that is what the defendant initialed. And although the math may be close on that, it is not the basis for the aggravated sentence, which is the 12 years which was ultimately imposed. Most importantly, and if the court would allow me,
If I may, before you move on, doesn't he initial specifically a paragraph 14B that says he understands and agrees that there exist facts or circumstances surrounding the offense, et cetera, that basically, in this, the language of this, would mandate the court sentence him in the aggravated range?
yes, and that would be the designated aggravating circumstances in the statute, of which there were none in this case.
Where is the word designating in that language?
I am reading that into it because the statute itself enumerates those. And then there is the provision, notwithstanding any other provision of this statute, the court may, if it finds certain aggravating circumstances. May I read the following from the court to the defendant? And what that means is essentially you could be facing an indeterminate sentence in the Department of Corrections. If the court imposes a Department of Corrections, or you could be facing an indeterminate sentence on probation. It further states, and importantly, so in other words, if the court were to impose a sentence under this sentencing scheme, it would be from 2 to 6 years would be the minimum I could impose. The maximum that you could receive would be life or an indeterminate sentence in the Department of Corrections. And that is the colloquy that we have noted in our brief as being the most critical colloquy in regard to the sentence that the defendant could receive. And the statutory scheme provides that the defendant is to be sentenced to life. Therefore, it is our view that in this case, the simple solution would have been for either the court to stop the proceedings and enable everyone to properly advise the defendant and have the proper paperwork, or that the court, during its colloquy, unmistakably tell the defendant that if I sentence you to the Department of Corrections, I am required by statute and have no discretion, the sentence will be life.
Thank you, Mr. St. Battery. Your time is over. In fact, Mr. Laney, if you'd like an additional minute and 30 seconds, you may have it.
I apologize.
No, I let you go. I'm sorry. Do you have any further comment?
I'm not sure I have anything to add, Your Honor, to what I said.
All right. Thank you, both counsel, for your very helpful arguments today. The case People versus Carbutt is submitted, and an opinion will issue in due course. Thank you. The court is going to be in recess before our 10 o'clock docket, and I believe some counsel are here for 10 o'clock, but not all. So the bailiff may announce recess, and we will reconvene shortly.
All rise. Court will be in recess.
Counsel, do you have any questions about oral argument procedures? You both received those, all right. And everyone in the audience, please turn off your electronic devices as it interferes with our recording equipment. This case is being live streamed. It will be on our website. If there is anything confidential, just take that into account as you perform your oral arguments today. And Judge Carparelli does want to address one issue before we get going.
So I want to disclose to the parties that Ms. Donnelly was an intern in my chambers when I was a full-time judge, and that I've known her since then. She's also in the same inn of court that I've been in. And over the years, I have maintained contact with her, and I think in some regards one might say I've been a mentor to her, though I've not talked about this case and not talked about, it's not been a very close hands-on. But I want to disclose that to both of you. I'm confident that I can be impartial, and that is impartial in the sense that I'm going to favor neither side, and I'm not going to bend over backwards to make sure that Ms. Donnelly doesn't feel like I didn't treat her fairly either. But I want to disclose that. I want to give you each an opportunity to state whether you have any objections to me sitting on the case.
Your Honor, I have no objection off the bat. Thank you for the disclosure. I suppose, just in the interest of not waiving anything on further reflection, we reserve some right to further brief it if went back to my client and they felt it was necessary.
Okay? Ms. Donnelly, any objection?
All right, with that being discussed, we're going to go ahead and start our first case and our only case on the 10 o'clock docket, and that is Iannicelli versus Denver City and County, or Denver County Court. I would note, the panel did not send out a pre-argument question, but it was not addressed in either brief, and so we would like both counsel to discuss whether this case is moot.
May it please the court. My name is Kathy Donnelly, and I represent the appellant, Mr. Mark Iannicelli. The trial court decision to vacate the appointment of the trial counsel in the middle of a critical stage of the criminal proceeding violated Mr. Iannicelli's constitutional rights, both under the Constitution of Colorado and United States, under the Due Process Clause, Equal Protection Clause, and the Sixth Amendment right to counsel. At this point, it should go without saying, but I will cite the Supreme Court case that says so, which is Maine versus Moulton, that there should be no interference by the government, including the court, when it comes to the attorney-client relationship, specifically in criminal cases, that the government does not get the right to veto or interfere and dictate what steps a criminal defense counsel should be taking in a case.
But this was a civil case, was it not?
I'm glad that you asked that question. I was hoping that it wouldn't be a question because there is no dispute. It is an undisputed fact that the underlying case is a criminal case. That we're talking, this is called People versus Iannicelli. When it was docketed in the Denver County Court, it is undisputed that Mr. Iannicelli would have been exposed to imprisonment in jail for a period of time.
In the criminal case,
Correct.
but not as a result or in the civil case, correct?
There is no civil case, Your Honor. The problem that we're having is that the Denver County Court has this absurd process where anytime that there is an appeal, and that can be a direct appeal, it's not limited to 106 cases, which are interlocutory appeals. So anytime that the criminal...
I need to stop you there.
Yes.
I understand your viewpoint that because a criminal case from the county court that is filed into the district court as an appellate case is given a CV case number does not make it a civil case. I'll grant you that. But that's not what this was, correct? This was a Rule 106 action, correct?
A Rule 106 action based on violation of speedy trial in a criminal case.
But it was a Rule 106 action, correct?
That is correct.
Which is a civil rule, correct?
Yes, that is correct, that the criminal rules in Colorado do not make an exception for criminal cases. So anytime that you are raising a writ of mandamus, what used to be writ of mandamus, now special writs under 106, there is no specific procedure that would allow a criminal defendant in county to district court cases to raise that issue.
But he could have
The
raised
same
it on
way-
a direct appeal.
And if I may elaborate, Your Honor, that the same is true about Rule 21. Rule 21 is a part of rules of civil procedure. It's not a criminal rule. The Supreme Court of Colorado has never recharacterized a criminal case as a civil case and said that you can't raise the speedy trial issue under Rule 21 because it's a civil case. It is exactly the same thing. The only difference is that because we are coming from county to district court, we are using Rule 106 instead of Rule 21. And the reason for that is that we have 106. Otherwise, we would have gone up on Rule 21, but the Supreme Court would have told us, you have 106, why don't you use 106? And that is established case law in Colorado over and over, and I have cited the cases, that this procedure has been used to raise the speedy trial issues. And more importantly, and it is not my words, it is the Supreme Court of Colorado again, in Cannon City versus Maris, the court specifically says, and I quote, label the judicial process as one well. No resort to subtly can refute the fact that the power to imprison is a criminal sanction. So when a criminal defendant raises the issue that you violated my speedy trial rights, he hasn't switched from a criminal case to a civil case. This is not a separate civil action. This is not a 1983 action. This is not a civil lawsuit in a separate case. This is still the continuation of the same case using the method that is available to the criminal defendant via rules of civil procedure, unfortunately. And we can ask the Rules Committee as to why we are not making a distinction so there is no confusion. And that might be something that the court would want to consider. But based on the Colorado Supreme Court established case law, and the Supreme Court of the United States, that I'm sure that all the federal cases would agree, you cannot change the nature of the case by just merely giving it a civil case number. So moving on from that part, the second issue still remains, which is we have the district court judge in the middle of the proceeding on appeal, unappointing, for lack of a better term, the trial counsel. And the only reason that we talk about the budgeting issue in this case versus the other cases that it wouldn't have been an issue is, again, the particular structure in Denver County cases. Because usually the Federal Public Defender's Office or the ADC is in charge, the funding would never have been an issue because the court would not even have the authority at that point to unappoint counsel and cut off the funding. In any other case, if there was an issue as to getting authorization for proceeding with a 106 as to a reasonable method, that the council would have gone to ADC, would have gotten authorization from an independent autonomous body that does not have to deal with any interference by the government, including the court, and that authorization would have been issued and everything would have been fine. And I've cited similar cases where the PD has taken up these issues and speedy trial matters all the way up, that the ADC has done it. And obviously, if Mr. Iannicelli could have afforded private counsel, he would have done the same. So the only time that has become an issue is where the county court has decided, and interestingly enough, what we are dealing with the same actors who are unfortunately parties in this case and in charge of the funding in this case, who have decided we are not going to pay, which is interesting that I wouldn't have raised the payment issue, it's a very secondary issue. But since my opposing counsel, my dear colleague and friend, has brought it up, I would like to bring to the court's attention that to this date, even though the invoices had been issued in 2016, the Denver County has specifically refused to make any payment to Mr. Iannicelli's counsel in this case. And if that is an appropriate issue on remand, I think it should be addressed. That might require a limited remand to address the payment issue, since the only argument raised, and I still question the authority of actually the city of Denver to even be here today, because we haven't seen any citation that would authorize them at this point to be here.
Ms. Donnie, let me back up again. As I understand it, the claim and charges against your client were dismissed. So could I direct you back to why this is still a pending action and why it's not moot?
Sure, Your Honor. Unfortunately, as you know, we haven't had the opportunity to brief this issue, but I would raise 2 points. One, that the clearly established case law states that neither the prosecution nor the court has the authority to force a criminal defendant to choose between constitutional and statutory rights. What happened in this case is that by vacating the order of appointment of counsel during the 106 proceeding, the court made Mr. Iannicelli to choose between his constitutional right to counsel under the Sixth Amendment, his right to due process, and his right to equal protection of the law, and his statutory right to speedy trial. And that is not allowed. That is something that the mootness doctrine does not cover, and is specifically held in United States versus W.T. Grant, 345 U.S. 629, and I'm happy to brief this issue since this was not brought up before the oral argument further. In fact, actually, I requested the opportunity to brief it further, that the defendant is, in this case, like the defendant in the case before the Supreme Court, is free to go back and do the same thing to Mr. Iannicelli and all other criminal defendants in county court. This case cannot be moot because this is not about this one case. It is categorically, as Judge Toe pointed out, saying that 106 cases are civil cases, and criminal defendants whose counsel is funded by the Denver and City and County of Denver somehow are in this separate category whose rights are different. So they don't get to use the same procedure, the same avenue, the same appellate remedies that are available to all criminal defendants and go forward with it. We are going to make an exception and say, because we pay your counsel, we can take away your counsel anytime. That cannot possibly be moot by the mere fact that we won on the initial proceeding and the charges against Mr. Iannicelli have been dismissed. If I have answered the court's question at this point, Judge Dunn.
Your argument is that it would not have any direct effect on your client, Mr. Iannicelli, but it would be a matter that there would be some precedent set if we address the merits of the case.
Your Honor, actually, if you had asked me this question a few months ago, I would answer that it actually can have still an effect on my client as well, because as you know, and that was one of the reasons that I bored the court with the full history of this case, which is a fascinating history of how we have come to this point in time in City of Denver that we go and actively prosecute people who are exercising their First Amendment rights. So what has happened is that in retaliation for exercising his First Amendment rights, Mr. Iannicelli has been subject of various allegations and complaints against him. So I wouldn't be surprised that he's going to be charged again very soon in one of these cases, because he has been exercising his First Amendment right to hand out jury notification pamphlets in front of the courthouse. And that's then still an issue that is out there, even though the federal court has specifically ruled that it was exercise of his First Amendment rights. That issue is before the Supreme Court. So it is not moot in that way either. Mr. Iannicelli can be, in effect, subject of the same thing again before the county court. But aside from that, as the court is aware, the majority of the people who are subject to criminal charges in this state, unfortunately, are coming through the county courts. And any time that you have a criminal defendant, and because of the fact that these are misdemeanor cases, they don't get ADC if it is in municipal courts, not in county. So if it is a GS case versus an M case, that then eventually they would get court-appointed counsel, and this is something that would happen over and over and over again.
Thank you.
If the court does not have any questions at this time, I would like to reserve the remainder of my time for rebuttal. Thank you, Your Honors.
Good morning. May it please the court, Jeffrey Klinksborn for the Denver County Court and its Chief Judge, Judge Spahn, 38997. Find myself in an unusual position here, certainly not one that I've ever been in before, standing at the podium without an argument on the merits because the county court has not taken one. Ms. Donnelly asked under what authority we were here. I would say it's because we're in the caption, and the appeal went to us, and we responded, as it's stated in our brief, just to clarify the facts that we believed had been misstated, and to defend the integrity of the city attorney's office and the county court on the facts, but took no position on the merits. So let me address the mootness question that Judge Dunn asked the parties to address here. I think it splits into several potential issues. One is, what exactly is being appealed here that could be mooted? It is, in essence, a sort of interlocutory appeal of an order that was not a final order to the merits of the Rule 106 action. It was an order revoking an appointment. So that if it's just a question of whether that issue of whether Ms. Donnelly should be appointed counsel to Mr. Iannicelli for that case number and for that Rule 106 action, I believe that is moot because that Rule 106 action is closed. If the issue, which is really the practical issue of the appointment, is, as Ms. Donnelly already brought up, whether Ms. Donnelly herself is entitled to payment for the services she rendered as court-appointed counsel to the defendant. Whether that has been mooted or not, I have no information. I can tell you for certain that it's not in the record on this appeal. So it's not been provided to this court. Or to me, the city attorney's office doesn't, for obvious reasons, get involved with payments to appointed counsel. Another issue that the mootness question might shade into is the question of what relief is available or even requested here. The typical relief, as I understand, for a Sixth Amendment violation is a new trial. I don't believe that's what Mr. Iannicelli wants here, since he prevailed on the 106 and the criminal case was dismissed. So whether this court has any relief that it could give to Ms. Donnelly in the posture of this case is another sort of mootness-related question. The other issue that the mootness question raised in my mind, again in the Sixth Amendment context, is the question of harmless error. The recent cases show that some forms of Sixth Amendment violations are subject to the harmless error analysis if they didn't infect the entire trial, but instead were limited to an isolated hearing or other event in the underlying criminal trial. And those are subject to harmless error. And if that's applied here, I think, obviously, again, since Mr. Iannicelli won essentially his appeal in the Rule 106, there's no harm to him in the immediate proceeding in the controversy at issue. Those would be my points on the court's mootness question. And unless the court has other questions, I think I will not take up any more of your time.
Actually, I have a question because I understand that you responded regarding the fee issue, and that may be an overarching issue, but the opening brief itself doesn't actually address fees anywhere. So were you doing a preemptive comment in case it gets remanded, or I was just trying, they didn't really match up, the answer brief and the opening brief in that regard.
Well, I think it goes to how I described the mootness question a minute ago, that there's the legal question of the appointed counsel, but then there's the practical effect of that question, which is, which here again doesn't affect Mr. Iannicelli at all. The proceedings already ended in his favor. Who it affects is counsel and her right to payment, which is an indirect effect, I suppose, on Mr. Iannicelli and his choice of counsel. But that is where the discussion of fees came from.
Thank you. All right.
If there are no further questions?
Nope, we're
Thank
good. Ms. Donnelly, you have 3 minutes and 52 seconds for rebuttal.
I'm afraid I would have to ask the court to strike any argument on the merit that my colleague is making today, considering that they took no position on the merits of the case. But considering the fact that there seemed to be a confusion between the harmless error standard and mootness, I would like to clarify that first of all, the violation and deprivation of right to counsel can never be a harmless error. That is a structural error no matter when it happens, and that is established case law. Whether the question is moot is a separate issue that I addressed, and based on the Supreme Court case that I cited, and I quote, "The defendant is free to return to his old ways. This, together with a public interest in having the legality of the practices settled, militates against the mootness conclusion."
But could the same result, if what I'm hearing is essentially a capable of evading review argument, where would it not be just as proper to present this in a declaratory judgment action saying, please declare the rights of the parties, and then that issue could be properly appealed in a non-moot setting? In other words, is it really evading review, or is it just not the right venue?
This happened at the district court. So a declaratory judgment would be filed with the district court. We asked the court to reconsider its ruling and cited the authorities. The court denied the motion without any explanation. If the court was willing to issue a declaratory judgment, it would have.
Right.
That is why we are here.
You're misunderstanding me. In this case, to argue capable of evading review, you have to acknowledge that this case you can get no relief in. Mr. Iannicelli, we can give him no relief because he's already had his case dismissed. It's the best case scenario for him.
That is undisputed, Your Honor.
So
Yes,
even
yes.
if this were structural error, the outcome would be we would reverse the outcome, which means we would undismiss the case. I'm quite sure that's not what you're asking for. So what I'm talking about is, in general, to present the issue that you want resolved to a court for resolution. Could it not just as easily be done the next time this pops up with, including in your 106, a declaratory judgment request?
Your Honor, that is a very bad guidance to the district courts and to the county court, I am afraid, because that would put the burden on a criminal defendant and the counsel to be one, aware of the particulars of this case, that if you do not issue an opinion, there's no guidance on. Two, I would completely disagree that under any circumstances, the result of this appeal would be undismissing the case, because the city and county and Judge Spahn never appealed the merits of it. That is done. That is going to be always uninterrupted. So coming back to the mootness issue, that is an issue that is going to be evading review if this court does not address it head on. And that is why the Supreme Court says that the case may nevertheless be moot only if the defendant can demonstrate that there is no reasonable expectation that the wrong will be repeated. And today you had the counsel saying, or having the opportunity to say, that this was never going to be repeated, and he did not say so. In effect, that means that it will be repeated, and that is exactly the plan for all of these cases. And as to the fee, I'm afraid I have to say Mr. Grinsprung was CC'd on correspondence with the city, having refused to make the payment since 2016. So he has been aware of the fact that the city is not paying. And one of the remedies we are asking is a remand to address that issue.
And to clarify, as I read Judge Robbins' order, he removed the appointment effective the date of his order of removal, not backdating it to when he had appointed you. You haven't been paid from the date of appointment up until that date either?
May I respond? I see that my time is up.
You may.
I have not been paid on any of the invoices in this particular case since the beginning.
Right, thank you, Ms.
Thank you,
Donnelly.
Your Honor.
Thank you, counsel, today for your arguments. This case will stand submitted, and an opinion will issue in due course. That concludes our docket for today, and the court will be in recess. The bailiff may so announce.